It's a legal battle we've been following for months now. Joe Kennedy says he lost his job after he refused to stop praying on the football field. He used to coach at a public high school in Washington State. Kennedy's lawyers say his faith requires him to give thanks through prayer at the end of each game. But lawyers for the school district argue Kennedy's prayers put pressure on kids to join him. Today, conservative and liberal justices both raised concerns about coercion. But still, the court's conservative majority appeared inclined to rule for Coach Kennedy. Here's CNBC's Scott Cohn.
When we met Coach Joseph Kennedy in Bremerton last month, he said the school district's actions struck at the heart of his First Amendment rights.
I don't want anybody to ever have to lose their job because of their faith.
But where's the line between his right to practice that faith and the student's right to be free from religious coercion by a government employee? That was at the heart of nearly 2 hours of oral arguments before the High Court, with the liberal minority suggesting the coach's public prayers at midfield crossed the line.
That puts a kind of undue pressure, a kind of coercion on students to participate in religious activities when they may not wish to, when their religion is different or when they have no religion.
But conservatives, including Justice Clarence Thomas, pushed back on the notion that Kennedy's personal prayer amounted to the government endorsing religion.
Normally, when I think of government speech, the government has a message and someone is communicating that message. How would it be government speech if, as it's happened in this case, the government objected beforehand?
Kennedy insists he's just fighting to be able to say a brief private prayer after the game at midfield. But even some of the court's conservatives noted that his post-game prayers became way more public.
What if the activity on the field did not consist of this kneeling down briefly, but something more extensive? Standing up on the 50-yard line, arms outstretched, engaging in audible prayer.
Which is exactly what Kennedy did. Even his lawyer, former U.S. Solicitor General Paul Clement, acknowledged that Kennedy's public prayers, which became a national spectacle before the coach lost his job, came closer to the line. But he said Bremerton and other districts are operating under what he called a misguided interpretation of the First Amendment, and he urged the justices to ease the limits on religious expression in schools. The district's attorney said Kennedy's prayers were clear coercion of students, some who were as young as 14. Kelly, a ruling in this case is likely in June.